no objection. In fact, we've never seen some of the testimony.
Testimony that Special Master Whitten, Amy Whitten, took was in the presence of Mr. Smith and maybe one of his assistants, and in the absence of the Attorney General's office. It was, what's the best way I can say that, super secret. She made some comment in here about these were sensitive matters that identified potential targets for grand jury investigation and what purported purpose there was to have these people subpoenaed and who was being investigated, and some sensitive stuff that she obviously felt at that time should remain sealed until whatever investigation culminated in some official action.
Hang on one second. His recollection of that is, and the reason that he wants it in particular, they have access to it, is because he believes, because Ms. Whitney making some comments about the investigation of what's going on, and pretend to indicate that he was making legitimate criminal investigations versus his pending criminal case. To me, anything involving Christopher Butler, who is the part of why Mr. Smith's indicted, ought to be disclosed to Mr. Smith, regardless of any public need for it, regardless of whatever it was that Ms. Whitney referred to that she thought it kept secret. But in any event, Mr. Smith needs access to that, and anything that's discussed about Mr. Butler, and also anything that's discussed about these two assistant attorney generals who are also at the heart of the problems between the attorney general and Mr. Smith. So we're strong and right.
Well, let me ask this. Did Mr. Patrick Beasley, has he been indicted by any chance?
No, sir. If you want to make, I don't know whether it's been a public record, but it's been in the news media. I want to say it's been, no, it has been in the record because we made some pleading about it. Mr. Smith was trying to subpoena these two assistant attorney generals.
Mr. Patrick Beasley is on your person.
Because Mr. Butler believes that they're the people who threatened him in the jail. He was trying to get them over there to be questioned. And our pleadings allege that they called Mr. McBride, and we're trying to make inquiries of Mr. McBride about whether they were subject to a grand jury investigation.
Well, let me stop you just a minute. I want to try to keep separate in my mind what is discoverable in the pending indictment against Mr. Smith under Rule 904, which he hopefully is going to get everything he's legally entitled to get. I want to separate that, if possible, from this sealed, ongoing investigation at the time it was occurring. I guess I'm trying to rationalize in my mind, is there any necessity for this remaining sealed at the present time?
I would say no, there's no necessity for it. And the people involved know Mr. Smith was investigating them, so it wouldn't be.
What about Felicia Hall? Has she been indicted by any chance?
Mr. Smith indicates it was never in the plan to indict Ms. Hall, so she would be.
What about Kevin Jackson, Director of Constituent Services with the Department of Corrections?
No, he was trying to get some information from him, but there was no intent to indict him.
What about Lee McDivitt, criminal investigator for the Attorney General's office? She's presently under indictment.
No, sir, and there was no, I believe can't represent to the court that that there might not in the future be some allegations, criminal allegations against Mr. Dick. We don't have, there's no present plans to pursue anything against Mr. Dick.
The Attorney General's Office position on case number 16-0026.
You know, we're in the position of not knowing much at all about what this is good to discuss with the special master, and certainly special master was satisfied to the extent that except for the one that Judge Bill, we're not lost, is my recollection.
Yeah, y'all correct me if I'm in error. Paul, Judge Green, following the recommendation of Special Master Amy Whitten, authorized the issuance of a grand jury subpoena to all these individuals other than the sitting circuit judge, Jeff Will. Was that ever done? Were these people ever summoned before?
That's what I was about to say. Nobody ever pursued that any further. We think whatever reason there was for sealing this material then has apparently been abandoned. If Mr. Smith says it needs to for defense, certainly if there's something involved with the state, would like to see what's in there ourselves.
Mr. Horn, I'm going to, at least to this point, take the language of the Supreme Court's order with sufficient broadness to include case number 16-00026 and grant your motion unsealed. That case also.
Yes, sir, I'll prepare. Your Honor, the next one is 16-00120, capitals TTG.
Let me see if I can locate that one, please. Council, to summarize what appears to me to be all of the contents of case number 16-120.
Yes, sir.
There's an order signed by Judge Green dated February 19, 2016, ordering the sealing of all documents in this cause. Included in the documents is a motion to recall an impaneled grand jury and to appoint the Mississippi Office of the Attorney General as pro tempore prosecutor. The motion references a July 20th, 2015 letter to the U.S. Department of Justice and the Federal Bureau of Investigations sent to the Attorney General's office. It is signed by Stanley Alexander on behalf of the Attorney General's office. It includes as exhibits a photocopy of the letter from the city of Jackson, apparently the police department, addressed to Robert S. Smith, district attorney, including a host of potential indictees to be presented to a grand jury. It also includes a letter from the Federal Bureau of Investigation and the U.S. Department of Justice to the Attorney General's office asking for assistance signed by Robert Culpepper, Special Agent. It includes recusal orders by Judge Kidd, Judge McGowan, notice of hearing for March 22nd, 2016. An order dated April 4th, 2016, signed by Judge Will, apparently with the district attorney's agreement that he had no objection that the Attorney General's office would present cases as they relate to Mr. Turner to the grand jury. And then your motion to unseal and intervene included. Your supplement to the motion to intervene and unseal was included. And then there appears here
Your Honor, that's an index Judge Will filed with a seal response to the Supreme Court.
that's correct. So, I mean, Mr. Smith was apparently present at the hearing, had no objection to this, and it was an order entered by Judge Will. I know no known reason for this, unless the information from the Jackson Police Department and the FBI still involves some ongoing.
Not knowing all the names that are listed as potential defendants, Your Honor, I couldn't tell you whether they've all been charged. I don't know that. Mr. Alexander would be the one who could possibly clarify that.
Well, just one moment.
Mr. Smith says that no other matters to be resolved in that objection on the other defendants that have not been resolved.
In this exhibit, there are 33 people identified by name with potential criminal charges. All listed here. Those all those individuals have been processed with either no bill or true bills returned.
I cannot answer that, Your Honor.
Mr. Smith said either no bill or true bills that go through the record system.
The reason I'm asking that, this memorandum is dated May 19, 2014, so that's in excess of 2 years ago, close to 2.5 years ago. So it would seem to me that
Your Honor, Mr. Smith says there were orders entered ex parte without his knowledge. It could be somewhere in there, he don't like that. So far as he knows, there's a person presented to the grand jury. One way or another.
I take that to mean, Mr. Wade, you have no objection to unsealing of case number 16120.
Now, Your Honor, may I inquire, does that have the testimony of agent you referred to here? Is there a transcript in there?
No, sir, there's not in this file. No.
Your Honor, as I understand, Clarion-Ledger question, and we agree that the transcript, so, we're going to try to ask the court to transcribe these proceedings, so that we can clear that in the process.
I do not know if a court reporter was present, if there was one present. I don't know if the testimony was transcribed. I don't even know if the transcript exists. But all I know is it's not in this file in the clerk's custody. A transcript is not. You may be entitled to that to discovery in the pending indictment, but if you are, you'll get it if it's under 904. But it's not here in this unit.
My understanding of the Ledger's motion also to allow us, for example, to go to court and request a transcript of that hearing.
Okay, well, if the transcript's not a public record, it isn't filed with the clerk. I don't know how I can accommodate you if it's not filed as a public document.
But there's no prohibition against either Clarion-Ledger or parties here requesting the court to prepare a transcript at their own expense, right?
I wouldn't know of any reason unless maybe Judge Will orders this court reporter not to do it, then we'll have another hearing on something. I assume But it may be that something exculpatory or discoverable under the existing indictment that would entitle both Attorney General. I assume you don't have a copy of any transcript.
Not that I know of, Your Honor.
Let me ask why we're here, Your Honor, because this is one of the most major concerns, getting that transcript. And our understanding was that we couldn't get it as long as an order setting the record, we wouldn't be able to contact the court or get it. If I understand the Attorney General correctly, he has no objection to our contacting the court and getting that transcript, am I correct?
We have no objection. I know there's been some talk about testimony, especially both that one.
I've heard that mentioned, I've seen it in some of these pleadings, I've seen it in maybe even some media accounts. I have seen no, to my knowledge, I've not read any testimony under oath from any special agent Robert Colfax for any of the stuff I have seen
Right.
as of right now.
Neither have I, but if it is to be transcribed, it can be transcribed. The Attorney General office has no objection to the disclosure.
All right, Mr. Warren, I'll order the unsealing of public documents in case number 16 CV00120.
Yes, sir, and for the record, may I include in these orders unsealing that the parties may order transcripts if there's testimony taken as been transcribed?
Or may request that the transcript be ordered and the parties here, neither party has any objection to that being done. I certainly don't.
Yes.
I don't want to exceed the scope of my authority here. It may be that you're entitled to that, or Mr. Wade's entitled to that, in his discovery under 904, regardless of what the Clarion-Ledger may or may not do.
Well, I'll include that in order, of course, consideration by order of transcripts being transcribed, or requesting transcripts.
All right. The last one I have is case number. My number is 14-9004.
And that's correct, 16 is the typo.
Okay, I've seen it written both ways, and I assume 16 or either 14, one of the other was a typo.
Your Honor, in support of this motion, may I call the circuit clerk's witness?
You want to call the circuit clerk?
Yes, sir.
Ross will come around. If you have no objection, I'll waive the formal as an officer of the court.
Yes, he's an officer.
Now to testify truthfully, Mr. Wallace.
Raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
State your name for the record, please.
Zach Wallace,
And what job do you have, Mr. Wallace?
Hinds County Circuit Court,
And how long have you been Hinds County Circuit Court?
since January 2016.
And what job did you have prior to that?
Deputy clerk
How long?
for 18 years since March 1997.
14-9004, would you tell the judge in the court what that file is?
149004 is a administrative number just for record keeping only of all the orders not pertaining a case number, so the clerk will keep a record of it. Example, like if the court reporter increases salary or the law clerk is appointed to that particular judge, orders like that.
And when I filed originally the motion to unseal 14-9004, these Molly Ryan, Ms. Wolf, Clarion-Ledger contacted you about access to that file, is that right?
Yes.
And what did you do in response to their request?
Request, I sealed it. Once I found out that it was a document filed in that particular number, I sealed it because there was some kind of based on the filing system, I didn't know that someone would file documents under that number.
Okay, let me back up. You remember I filed a motion to unseal 14-9004 on behalf of Clarion-Ledger. Remember that? And I had a conversation with you, and you told me that the two reporters would come view the file and make copies.
Yes.
Is that right?
Yes.
And did these two ladies come view and go through the file and make copies?
They viewed the file, I don't know if they made copies or not. Not really sure.
But you would have allowed them to make
Yes.
And what is the status of that file now in terms of being open or sealed?
Should be sealed.
Okay. Tell the court what authority you have to seal that file.
As the clerk, I have full authority to seal the file.
Authority based on what, sir?
Based on the filing system, NEC, Mississippi Electronic Courts.
I'm sorry, I didn't mean to interrupt you. Go ahead.
Okay. As of that day, once I found out that a document was filed in that particular file, I contacted the Mississippi Supreme Court, Mrs. Catherine Porter. She's the project manager, and her suggestion was if I don't want anyone filing it under that particular number to seal it. And due to that conversation, I sealed that particular number.
Are you still placing documents and pleadings in 14-9004?
Yes, all administrative orders. And if I may explain, case number 14-9004 is just for Judge Will, administrative orders. Same with 14-9001 for Judge Green, 14-9002 for Judge Gowan, and 14-9003 for Judge Keel.
And if this afternoon, Ms. Bryant, Ms. Wolf from Clarion-Ledger came to see you and asked to go through those 4 administrative files, you would again give them access?
Oh, definitely, yes.
So if you're giving them access, then you're not putting these documents on the electronic filing system for what reason?
Because with the filing system, it will, if I had it unsealed, it will allow attorneys to file documents under that number. And that's not an actual case number. Not an actual case at all.
Let me understand your lingo. The way I understand it, the case is sealed. You can't get into it electronically or look at the paper. When you say sealed, you're just talking about electronically.
Yes.
So the file will remain open for citizens to come review the contents
Yes.
of 14-9001, 14-9002, 14-9003, and 14-9004. Is that correct?
That's correct.
So any citizen could come review the file, they need to come to your office and look at the file.
Correct. If I may add,
Yes, go ahead.
those numbers, like I said, is not a case. It's just a filing system. In the past, before January 2016, administrative order was file stamped in the clerk's office and just placed it in the file folder and set to the side. Whereas now, I'm able to file stamp it and pull up the electronic copy whenever requested.
I didn't understand the last sentence.
Okay.
You have an administrative file, you have paper and pleadings and bills and other things in it, right?
Yes.
And you can pull that file over electronically,
Yes.
but nobody else can.
My other clerks can also.
But nobody else.
No one else can.
And that's for your convenience because you don't want attorneys on the electronic filing system filing documents in those files because those documents don't belong there.
Not belong there, but they're not, it can't be responded on. I say that.
What do you mean by that, sir?
That when a judge filed an administrative order saying that they're going to appoint a law clerk to their courtroom or increase the salary of a court reporter, those documents are not there's no response for those documents.
What do you mean no response?
Like attorney cannot object to those documents.
So administratively, you just want to keep that file electronically closed so that documents that don't belong there won't get filed, is what you're saying?
Correct.
Can I ask a follow-up question if there's no objection?
Please, you're going to more about this than I do.
Mr. Wallace, I think what I understand you saying is that when an administrative order, for example, is signed by Judge Will and given his number, that is 14-9004, that document, that order is available for public inspection in your office. So when you put that order in the NEC system, you put it in as a sealed document to prevent or discourage any for example, filing something in the NEC system in response to that order.
Yes.
Is that what I hear you say?
Yes, sir.
But the file itself is still public record?
Yes, sir.
Okay.
May I confirm you?
Council approach the bench, Mr. Ramon.
Our reporters spent some time there too, they didn't publish anything, to make some copies. It's a law, so we don't access to copies. All over his office. I wanted to make sure that at least physically open to families. No, sir,
Administrative orders of the court. Everybody can take it.
Back on the record. After the bench conference, I'll summarize my understanding of our discussion. Administrative file number 25C11-14-CV-09004-JAW. Apparently, best I can ascertain, is administrative court file that contains voluminous numbers of orders, letters, documents that were filed, given that docket number under Judge Riddle. And as I understand it from Mr. Wallace's testimony, those remain public records available for inspection in his office. The pertinent issue in this case is the order signed by Judge Will on June 23rd, 2016, as it relates to the temporary disqualification of the Hinds County District Attorney. Neither the Attorney General's office nor Mr. Smith, I think, have any objection to the unsealing of that order. Is that correct?
We don't do.
No, so we don't, I'd like to ask a couple questions, if I might.
Yes, sir. Excuse me. I'm going to give you that opportunity.
I don't have any, no, of course we have no objection to what I was saying. I want to clarify a couple of things, while I understand.
All right.
Mr. Wallace, sir.
Very happy.
Good, and just about one particular document that's in there. There's a document in there where Mr. Smith's authority as district attorney is canceled in part. Certainly, if you just take it away. You're familiar with that document, I do.
Yes.
All right. And these administrative files that you have, do you ever find, is that a unique type thing to affect somebody's rights, like Mr. Smith's were done, or they enter these administrative orders that might affect other people's rights?
Ask it again now.
Well, you would agree with me that an order canceling some of Mr. Smith's duties as district attorney would affect his rights, that it would affect Mr. Smith's rights. We agree with that?
Right, yes, yes.
Do these administrative files contain other orders of that nature where somebody's rights are affected?
From my understanding, no.
That was a unique situation with
Yes.
that file. Do you remember talking to me on the phone where I attempted to file something in that file, asking that Mr. Smith have access to transcripts?
Yes.
Documents? You remember calling me and telling me I could not file it in that file?
Yes,
And that you recommended I file it in, I believe, the county criminal matter. Am I correct?
that's correct, 16624.
And you're aware that I didn't get that? I did
Yes, sir.
file it.
Yes, sir.
That's all I know. Well, I think, let me ask you, one other thing, totally different matter. Did you read the Clarion-Ledger this morning?
No.
Did not. Have you heard in some way that there is a contention made, or was written in the Clarion-Ledger that in the Butler criminal file, certain documents are missing from the file? Did you ever heard that?
Yes, I heard that.
Do you know of any documents being taken out of the file?
None have been taken out, but several cases I have heard like that. Not only just that particular case.
You've heard that somebody's removing the documents from a criminal file?
Not really removing the documents from a criminal file, but just the documents missing.
The documents are missing?
Yes.
How could that happen in your office?
That's a good question. My explanation would be there's a lot of people come to the office, a lot of traffic, attorneys, runners from other law firms, and they might just go and pull the file instead of making copies of it. They probably take the copy with them and take the original with them.
All right, let me ask you something while we're on this subject. We're here about just files in general being sealed. Is it a practice in the circuit clerk's office that in criminal cases, certain documents in a criminal file are actually being sealed? That is, a particular order, say, of a judge is being sealed and made inaccessible to the public. Is that true?
It's true.
All right, why is it that entries, that orders in a criminal case would be sealed?
Can't answer that. It's up to the judges.
Well, let me ask you this specifically. Is it true that in criminal cases handled by Judge Green, that she will sometimes let people out, say on their own cognizance or a small bond, let the person out of jail and refer that person to the Hinds County Probation Service?
I don't do that, this is beyond the scope of the hearing we're here today.
Your Honor, the issue about the practice.
It's not that. Mr. Wade is trying to introduce into this hearing part of what I understand to be his defense in criminal defense. It's inappropriate to do that.
Where you at?
Your Honor, I understand Your Honor's unseal these files, but we are very interested in, I mean, to me, it's an issue for due process and also an interest of the taxpayers and the public. What the Clarion-Ledger is apparently concerned about, and knowing whether there are criminal files being created, orders then sealed, and what's the legitimate reason for it. I think it's just a matter of public concern and it goes generally to the motion they file.
I'm going to sustain his objection. We'll address that in another time and another venue if necessary.
Thank you, Your Honor.
Any other questions, Mr. Wallace?
Nothing from the state, Your Honor.
You understand that? Absolutely. Thank you. All right, let me try to be articulate. I am going to authorize the unsealing of the order dated June 23rd, 2016, signed by Circuit Judge Jeff Will Jr. in case number 14-9004. That's an administrative docket number for that particular order. I understand all the other entries in that file are already public record. All right. That concludes, I think, everything that Clarion-Ledger has on the agenda today. So,
That's correct, Your Honor.
all right.
One more, please.
Yes, sir.
Nothing from you, Your Honor.
All right. Speak to the Attorney General's office and Wade, do you go and take about a 10-minute break and then meet back here in the courtroom if necessary to discuss some arraignments and motions to disqualify counsel? How do you desire to deal with that?
Yes, sir, that's fine. Your Honor, like I said, this is right over here while we're running.
You think that's possible?
Depends on what he have Mr. Dyke.
That was my real concern, is whether or not you can get Mr. Banks here. Would you give it your best effort? Because it would be appropriate and timely if we could do it all at one time. Just, it's a formality, I guess, but a necessary formality to get it done all at one time. All right, let's stand in recess for 15 minutes, then we'll reconvene.